talk a little bit about the reasons for this reform and why the EU is actually, why the EU has embarked on this reform. So the EU is in a way a newcomer to this field of foreign investment. If we look at the past, it was really the member states that had the role in this field. They kind of also invented the system. The member states have been concluding bilateral investment treaties since the 1960s. So the EU has got competence for foreign investment in 2009, and it really comes to the field at a time when the field is facing a lot of public controversy. And in particular, we have seen this with big cases like Philip Morris and Australia, or Vattenfall and Germany, the second ISDS case, where the foreign investors have been challenging different state measures, mostly legislative measures when concerns these two cases, which were made in the public interest. So we kind of have a clash between private interest of investors and public interest or policy goals that states wish to achieve, and which are then challenged through investor-state dispute settlement, or ISDS. So in a way, we can see that ISDS challenges, we could say that it challenges democracy, so the legislation which was made through democratic processes in the parliament and which reflects the will of people, and also challenges in various aspects, as also the rule of law. So how is the EU seeking to address these problems? So on the one hand, the EU wishes to rebalance that relationship between private interest of foreign investors and the public interest through more detailed protections in the investment treaties, but also by introducing or emphasizing the state's right to regulate. So preserving the state's right to regulate through different substantive provisions in international investment agreements that the EU is concluding with third states. And on the other hand, the EU also wishes to see more accountability of ISDS. And in that sense, the EU's vision of reform departs from a traditional investment treaty arbitration to a more court-like model, so a semi-permanent tribunals. And both of these ideas, so both the substantive, enhancing substantive standards, as well as enhancing procedural standards and replacing the dispute settlement model, seek to achieve or enhance the rule of law. So what is the rule of law? It's also good to give a brief idea of what do we mean by the rule of law. As lawyers, we see the rule of law as one of the core characteristics of functioning legal systems. But in the EU context, it's also important to emphasize that the rule of law is the core EU value that has been enshrined in the Article 2 of the Treaty on the European Union. And as such, the EU has an obligation to also then conduct its actions in line with the rule of law, so also to conduct this reform in a way that will enhance the legitimacy of the system. So if we have a better system, then there will be more acceptance of this system among different stakeholders, so among the member states, as well as civil society. So the EU's reform of ISDS is taking place in different contexts. So in the regional context, so between the member states of the European Union, in bilateral context, so with respect to EU's external relations with third countries, and also in a multilateral context, in particular in the UNCITRAL, the UN Commission on International Trade Law, where the reform of ISDS has been taking place since 2017, and the EU is one of the important actors in this multilateral reform. What is important to emphasize is that this reform is in many aspects really shaped by the EU's vision of the rule of law and the EU's legal system. So the way that the EU has framed the reform is seeking to ensure compatibility of investor-state dispute settlement with the EU legal order. So in the intra-EU dimension, when we talk between the member states or investment dispute settlement between the member states, the idea is that this investment dispute settlement will take place before domestic courts and ultimately the Court of Justice of the European Union. So in a way, the EU has eliminated investment treaty arbitration in the intra-EU context, with the idea that domestic courts should be the institutions before which these investment disputes will take place. In the extra-EU context, so when we talk about the EU and third countries, the EU envisages to replace investment treaty arbitration with the investment court system. And this is quite significant because investment treaty arbitration embodies a more ad hoc system of different tribunals which are not really connected to each other. With this investment court system, the EU envisages a more permanent, or we should rather say semi-permanent tribunals, which will be established under different bilateral treaties between the EU and third countries. So, for example, the EU and Chile, the EU and Canada, and so on. The long-term picture is really to actually establish a multilateral investment court, which would replace all these bilateral tribunals under EU agreements, so that we would have one place where all investment dispute settlement involving the European Union and the member states would take place. The EU's proposal for the investment court system and ultimately multilateral investment court in many aspects reflects this idea of the rule of law. So the court is supposed to ensure independent and impartial access to justice. So here we're talking about rights also which are guaranteed in the EU Charter of Fundamental Rights, so the right in Article 47 more specifically. And when we talk about independent and impartial tribunals, here we see really the emphasis on the access of foreign investors, in this context EU investors, to these tribunals, so EU investors investing outside of the EU, and these tribunals which will be independent from host states, meaning states in which investors are investing. And in a way, this should also contribute to the objective of free and fair trade. So here the EU is really combining several objectives, so free and fair trade, but also protection of EU investors abroad, as well as exporting its own rights and vision of what independence and access to independent tribunal is under EU law, although the standard is not fully the same as the application of that right within the EU. The idea of the court also means more transparency of the system, which is a very important aspect of the rule of law. As we know, investment treaty arbitration is confidential, and that is one of the key aspects of arbitration as a model. Also, we have a more open system because the idea of the court ensures that the proceedings will be open to the public in a way that ensuring public scrutiny of the system, which goes hand in hand with the rule of law. Of course, not everyone shares this idea, and if we look at the reform of international investment law, we can see that states have different ideas of what the rule of law is. So many states emphasize that there is no problem per se in investment treaty arbitration as a model. What this model needs is improvements, and states have been working in UNCITRAL to improve different aspects of functioning of investment treaty arbitration, in particular ensuring more independence of arbitrators through, for example, a code of conduct for arbitrators, which has been adopted in the UNCITRAL. Some countries also think that it is not necessary to introduce a court, but rather have an appellate mechanism that is going to ensure consistency of different awards coming from ad hoc tribunals, so that we actually have that second layer, but that we leave the first instance as it is in the form of arbitration. So the EU's idea really is to have a court of first instance and as well as second instance. And what we will have to see is how these negotiations in the UNCITRAL are going to advance. And of course, these negotiations are ongoing. They're envisaged to finish in 2026. And of course, for the EU, it would be extremely important to have the court. There are many issues that have been discussed in the UNCITRAL, and one of the core issues, which also comes back to the rule of law, is to what extent this is really a systemic reform of ISDS, because it looks only at procedural aspects at the dispute settlement. It doesn't really look at the substantive provisions, and these two elements are rather interrelated. So even if we have a new multilateral investment court, the system will still depend very much on claims coming from investors. The system will still protect only foreign investors, so some claim that there will be still imbalance in terms of protections because the system does not allow the same protections for domestic investors. The other problem is also that the system is not going to protect in the same way local communities, which can be adversely affected by this investor-state dispute settlement model. Talk about the acceptance or support for the EU proposal, there are many that are actually afraid that the proposal or the court will eventually basically institutionalize the flaws of the current ISDS system without necessarily improving it. The rule of law ensures control of law over politics, and it will be important that a multilateral investment court, if established, does ensure the control of law over politics, does ensure protection for foreign investors. And importantly also, what the EU's idea is really should states have more control over the system. So in many aspects, whether third states accept this idea of a multilateral investment court will depend on the ability of the EU to convince the states that its proposal, that the EU's proposal, ensures more right to regulate, more control over this of states over this system that has been highly controversial.